各位早晨。我哋
Members, good morning. We have formed a quorum and it's already the appointed time. May I call the meeting to order? That is the meeting of Bills Committees on ATML and Counter-Terrorist Financing, Financial Institutions Amendment Bill 2017 and Companies Amendment Bill 2017. This is the 8th meeting. Please invite the administration to join us. We're grateful to the secretaries for putting together such information within such a short period of time. Before the meeting, the administration provided a response to issues raised at a meeting on the 4th of January 2018. Paper 442/1718(1). Will the administration please walk us through the paper? Thank you. Yes, can we switch on the microphone for the Undersecretary? For the Deputy Secretary. Thank you. Yes, we have prepared a paper to respond to issues raised at the last meeting. As a result of the last meeting, we're going to move 3 more CSAs to the bill. Last time, members asked whether real estate transactions should only apply to transactions concerning the selling or buying of real estate inside and outside Hong Kong. So we are going to move amendment to Section 5A3 and 5 to clarify beyond doubt that it is immaterial whether the subject matter of a transaction referred to in these sections is in Hong Kong or elsewhere, to avoid ambiguity. And the second CSA is in relation to Section 53 B3, and that is the registrar of company will allow to disclose information to the real estate authority as well. And we are going to move a CSA to this effect. And we also agreed that designated non-finance petitioners can the last CSA did not mention whether overseas related regulated real estate agents should be a third party, and we're going to move a CSA to cover this, and this will then address the 3 areas of concern raised at the last meeting. So our paper has also clarified issues raised at the last meeting. So, Chairman, would you like me to go through them again, or is subject to members' views? So should the administration go through the whole paper first, because all the points have been set out very clearly. Mr. James Stowe? Now we are talking about the details of the bill, so we have to go through them very meticulously. Shall we give the floor to members to ask questions first? Or rather? All right. Members, do we have any comments or questions for the explanation just given by the Deputy Secretary? Yes, I'd like to know which point he was referring to so that we can focus on them. I think that's about Section 5A35. That's point number 1. No, Chairman. I've got paper number 444. There is a revised edition. Are they already the latest version? Yes, this is a revised edition. That means it has included all the CSAs. Can then perhaps go through the CSAs point by point? Paper 444. You know, with color print. 444. We will talk about paper 442. Oh, you're referring to paper 442. Oh, you're not with us? Oh, I'm afraid not. Sorry. I thought the latest paper should be 444, number 444. Okay, 444 bracket 01 is government's response to our BC, and bracket 02 is the latest CSAs, right? And how is it related to 444? How come you have got paper 444? I have paper CB1 444 in front of me.
444個 mark up
444 is a marked up copy, but we're not yet dealing with the marked up copy. Have you got 442? Yes. I've bracket 01. 442 bracket 01. I've got it. All right. He has just elaborated to us points 1 and 2, but I have got a 444 marked up version. I've got a marked up version here. Let's sort it out first. The paper is dealing with paper number CB1442 bracket 01. Are you talking about 444 or 442? No, CB1442 bracket 01. Speakers off mic. 442. Are you referring to the color version? Do you want us to use the color version as the basis for our discussion? Well, it doesn't matter because we are doing a clause-by-clause scrutiny, and I think that is the spirit of our discussion. Now, I wanted the administration to explain to us its responses to our issues raised last time. The paper is CB1442 bracket 01. Have you got it? Yes? But he hasn't really explained this paper to us. He was very brief just now. Well, I was following him. All right, we'll do it again. We'll start it all over again. All right, thank you, Chairman. Starting from para 1, follow-up to meeting on the 4th of January 2018. Please start start from para 1. Mr. To, have you got it? Yes, annex, the annex to the paper. All right, bracket 01. That's our reply. First paragraph. At the last meeting, member talked about whether the real estate should be in or a local property or overseas property. Now, our policy is very clear. If you have a designated transaction, then you have to do due diligence and know your customer. You have to carry out that exercise. And both local and overseas properties are covered, and we felt that it was already clearly stated in the bill, but members wanted us to be clearer, so we agree that we should state clearly beyond doubt that it is immaterial whether the subject matter of a transaction is in Hong Kong or elsewhere. As regards the actual CSAs, and please refer to our amendments to 5A, but we believe that we should not just deal with property transaction. Under 5A, we have 3, 4, and 5. We also want to clarify that it is immaterial as to where it is. Now, if the designated transaction takes place in Hong Kong, then there should be due diligence and also other things. Well, you rely on the real estate authority to be the regulator, right? Then I have a concern about the jurisdiction. Real estate agents have to be licensed to deal with transaction of properties in Hong Kong, and is regulated by the real estate the EAA or the E. So now we're going to ask the authority to regulate is transaction involving properties outside Hong Kong, and they are required to maintain records. Now, if the real estate agent hasn't done so, in fact, it is not doing something within the license of a local license, and I'd like to know whether the authority has the authority to regulate or to discipline this real estate agent under the relevant ordinance. Thank you, Mr. To, for your question. If I may have a go. Real estate agents. Now we are talking about licensed real estate agents and licensed practitioners under the estate agent's ordinance. So long as the person is a licensed person under this ordinance, he will have to carry out due diligence, carry out customer due diligence. Understand that some estate agents deal with properties overseas, and the authority has jurisdiction over that, and the authority has recently issued a guideline. If an EA is involved in transaction of property overseas, the kind of customer due diligence has to be addressed. Now, I'm asking I'm talking about legal issue, not a policy issue. My point of law is, as far as I know, the authority under the EA ordinance may not have the power to monitor licensed EA not dealing with local properties. All right. If by means of this ordinance we are amending the scope of the EA ordinance to authorize the authority to do so, is a legal point. My question is, according to your understanding, is it that the authority already has that power under the EAO, or are we amending the EAO by means of this law so that the authority can discipline an EA if it hasn't carried out customer due diligence for a property overseas?
EA ordinance land already includes property outside Hong Kong. And properties, if you look at the definition of land in the EA ordinance, it says it applies, the definition of land applies, defined with reference to the Cap 219, which is the Conveyancing and Property Ordinance, and it says it applies also to property outside Hong Kong. And property outside Hong Kong is defined to mean an interest in land. And land is defined to include property outside Hong Kong.
Maybe I use English to ask more precisely. I know the definition, but you must put the definition into the precise context of the whole scheme of the EAA. I have many meetings with the EAA because I push for the greater scope of disciplinary power, possible disciplinary power of EAA over certain activity. That means buying and selling of property outside Hong Kong, okay, by a licensed Hong Kong agent. Okay.
Mr. To, our legal advisor, Mr. Low has some legal advisor to give. There is a corresponding amendment here to amend Cap 511, and that is EA ordinance to authorize, to empower the EAA to discipline an EA if it hasn't complied with this ordinance. And Mr. To, you're referring to a second tier. So this is amending the law. Now I'm asking the administration's understanding, because the government's legal advisor talked as if there was originally in the EAA. And my understanding is the original EAA is insufficient, but because you want the authority to help in any money laundering, so it appears that the law is giving extra power to the EAA. I have to have an answer from the administration. Chairman, the reason why I say this is important is because, yes, this is about jurisprudence. I understand you. Chairman, hold on. For the record, if the government is of the view that regionally the EAA has that authority, then it's a different view, different from my understanding of the ordinance. For a long time in the past, I pushed that EA should be penalized for doing certain things, but the government had reservation. Now, if you say that because the ordinance itself is not very clear, and you are going to add that through this bill, I can accept it, because you want to comply with the recommendations of FATF. But I just want to clarify this because this is important. Any response to Mr. To's question? Speakers off mic. Yes, we've discussed with EAA and also with his legal advisor. As said by the law draftsman, under the EA ordinance, whether it be land or property, the definition covers overseas land and properties. And the EAA regulates the conduct of licensed EA, and our bill here also regulates the conduct of licensed practitioners. So for anti-money laundering and counter-terrorist financing, the EAO doesn't have such provisions, but we have deliberately added that to the EA ordinance. So through this bill, we will enhance or we will add this requirement. The conduct of the EA will be regulated by the EAA. Transactions would include property both inside and outside Hong Kong. So, for the avoidance of doubt, we're making it clear that it is immaterial whether the property is in Hong Kong or overseas, so long as the transaction has taken place in Hong Kong.
So we have communicated this idea with the EAA, and we are in agreement. So my understanding is that, well, it doesn't matter. This follow-up is helpful in my other discussions. So this current understanding seems to be a little bit different from previous understanding. In the past, they said, well, this licensed real estate agent, they are licensed to conduct transactions in Hong Kong. That's it. But they can do it in an individual capacity, not as a licensed real estate agent. And but then anyway, you feel that it's already present in the first level. I thank you for that. No questions on paragraph 1. We'll continue with the document 442, bracket 02. The second point, in our last discussion, we talked about in the amendment bill, the business registrar, if there are TCSPs that are breaching the law and they are fined, we have to go back. The money will be going back to the fund, and the question was that, and it was raised by the legal advisor. It seems that under the Communications Authority, there's a different handling, but unless there is a specific wording where the funds have to go to any place other than the trading fund. So under our current amendment, we have not made any specification. So our intention is clear. That is, whether we have license fees or other levies or breaches and penalties, this will go back to the trading fund of the business registrar. So when the registrar is dealing with the trading fund, he will not be doing work ultra vires. That means any penalty that he has to administer, the licensee or the licensed person will have breached the law and their activities were beyond the permit of the practice guideline. Well, the company's registrar in our establishment subcommittee, they have added a post to deal with this. And in last week, there was a fine of, there was a license fee of $3,000 odd for 3 years. So, has this considered the addition of a post of a directorate level officer, or had you not taken into account this extra expenditure? Thank you, Chairman. The license fees or levies are to recover costs, and the costs have already included the recommended establishment of a new directorate post, and we also considered all the penalties, the renewing of license, all the staff costs and personnel costs. Everything has been calculated. So you won't have, in the coming year or two, have to adjust the fees, the license, because of the extra directorate post. We have done the whole calculation. So that would influence on whether I support the establishment subcommittee addition of a post. So in paragraph 3, we have another CSA. This is technical. On the last occasion, we talked about, if we refer to the other document, the document 02, or rather 04, in our CSAs, we will add another point, and you'll see that on page 3, 53ZK, the authority can make disclosure, and in our last discussion when we talked about disclosure, we did not say that we could allow for the registrar to disclose information to the estate agent's authority. So it seems to be more ideal if we allow the registrar to disclose that information, and we agreed with the committee's views, and we'll make an amendment. That is, if necessary, the registrar can disclose information to the estate agent's authority. This is a technical amendment based on our previous discussion, because you all felt that was more ideal. No, any more questions? Let's move on. On point 4, It's a drafting issue. Clause 53ZO. We talked about the time frame for prosecution. We do have the prosecution has to be done within 12 months. So when the registrar is made aware, the clock starts ticking, and the question was asked whether there was other drafting method. So our legal advisor looked at it and felt that this was not a new drafting practice. So in our paper to LegCo, we mentioned that a lot of ordinances, such as the marriage ordinance, the mandatory provident fund schemes ordinance, have similar drafting. Chairman, I disagree. I'm not going to argue. I'm just going to tell you that in some recent ordinances, you have used this practice, but the majority of ordinances are not using this formula. I think that is very dangerous. If they use the discovery time to start counting the time, I will make my own CSA. Well, let's move on to paragraph 5. On our last discussion, we considered the advancement of technology. We could make notification by email, and we want to spell out when we can use email. So here it's made very clear when the registrar can issue a notice by email. It's when the last known email address has been provided to the registrar in the relevant specified forms. Then the registrar can issue email. That means the person in the specified form has told the registrar and confirmed that is their email address, and please issue notices to the email address. Okay. Chairman, the specified forms does the applicant have to fill it out mandatorily? Your response is that, well, if they don't submit the email address, then they can't get their license. Well, we cannot make it mandatory. I'm asking, Chairman. Does that mean that if you don't have an email address, you can't get a license? No, because if they don't fill it out, we will clarify with them why they did not fill it up. If they don't have an email address, that does not affect the licensing. Okay, that's fine. We have it on record. Please continue. On paragraph 6, on the last occasion, a member asked, company service providers, they provide an address. So we looked at it in detail, and to comply with FATF requirement, they have it spelled out very clearly. In paragraph 6, 6C, they have to provide a registered office, business address, correspondence, or administrative address or other related services for a company, a partnership, or any other legal person or arrangement. So that would be covered under the TCSPs. So since FATF made it so clear, so no matter how you provide an address to serve as a company, that will be regulated. So I want to clarify that in paragraph 6. Mr. Toh? Well, then theoretically, the post office, when they provide a P.O. box, but the government is not regulated. Then, to put it bluntly, you will consult the professional bodies. Are there any industries? As I said, we have in Causeway Bay, they rent office space. Is there any business association, a real estate association, landlord association, and so on? Have you consulted them? Thank you, Mr. To. Regarding this suggestion, we had made consultation. So aside from inviting email responses, we had contacted the large business associations, including SMEs. We had consulted them, and they had also responded. Well, Chairman, I'll tell you that they would have never dreamt that if they provide an address for rent, that they will need a license under the TCSP regulatory regime. Well, that's going to be forced upon us, but I think you need to really educate them. You have to tell them. So it's $1,000 a year license fee, but I think it's pointless, really. Mr. To is correct. That's why when the law takes effect, we will do education and promotion. So companies that provide secretarial service or other SMEs, they will have to educate them. Mr. To's view is that we don't need to do this, but it's a FATF requirement, well, I'm going to serve an example. Let's say trade unions, they might have 20 subsidiaries and have correspondence addresses, and they need a license. So FTU might have some 50 subsidiaries. They don't know that they don't realize that they are providing secretarial service, and you need to remind them that they would never have dreamt that they would need this anti-terrorism license. Paragraph 7. On the last occasion, we talked about Schedule 2, 9B. We wanted to amend and allow FIs and DNFBPs to be more risk sensitive and have flexible options when they when they perform due diligence. They don't need to review the information all over again. So now we are just explaining that aside from utilizing technology, we don't require the FIs and DNFPBs to review all the previous information that had been confirmed previously. That's just a clarification. Then paragraph 8. Paragraph 8, regarding sections 53S, 53T, 53U, it says that a person has to obtain approval from the registrar to become an ultimate owner, partner, or director of a licensee, respectively. So it's about the definition of a director, and we say that any person who is a director, regardless of the name, but who is performing the duties of a director, even if they have not been appointed as a director. So if they contravene these 3 sections, they are still breaking the law. So legal advisor had said that it seems that in the stored value payment system, in the stored value facilities and payment systems, it's spelled out very clearly, and we're asked whether we could standardize that. But it seems that under the payment systems and stored value facility, there is an ongoing situation, and there's a fine and penalty. But here we're just talking about a breach or contravention. So if we can prove that a person is serving as a director, we can still they can still be caught by the law. It's not we don't have a continuing fine arrangement, so there is a difference. Mr. To? I have no special objection, but on the fees, they might not be a business. For example, FTU and the unions. Well, of course, HSBC trusts, they don't mind paying $1,000 a year, but for other situations, so if there is an increase in the levy, for all these license holders, not all of them are businesses. So in the future, your colleagues will have to deal with this. There might be some NGOs and so on. I'm just afraid that I forget this point. I just want to have it on record. 53 ST and U. In Chinese it says "dam," but in English it says "becomes," and so even if a person is acting in the capacity as a director, that would be included. And other than that, I have no other questions. Mr. Toe's concerns are that secretarial services and people who are providing some social services, they need to get a TCSP license and they have to pay a fee every year. So will the government provide any response to that concern? Just now, Mr. Toe mentioned that FTU unions, I recall, they did not register under the company's registrar. They were registered with the police, but they allow their subsidiaries they provide a correspondence address for their subsidiaries, and they are providing a secretarial service. Thank you, Chairman. The licensing regime deals with the people who are in this line of business in Hong Kong. So we have to look at the different cases. So if they charge a professional fee, they conduct this behavior or activity on a regular basis. But if it's not a business, it's not dedicated for profit. The address is just for family members. Then the registrar will not require them to apply for a license. So let's clarify. So those who are operating a business have to be regulated, but non-businesses are not going to be regulated. That's correct. Then that would be good. They should not be charged a penny for the situations that I mentioned. Let's continue then. On paragraph 9, in our last occasion, we talked about and the accountant's ordinance. There was a term under the professional accountant's ordinance.
Courses or allows. So we went back to see whether or not the same phrase is being used in other ordinances. In paragraph 9, we're saying here that in other ordinances, courses or allowance have also been used. For example, in the Financial Reporting Council Ordinance and also the Waste Disposal Ordinance as well as the MPF Scheme Ordinance. They all have used the same expression, courses or allows. Mr. Toe. Now, specifically, all these are new provisions. If you take a look at the MPF Scheme Ordinance and the Financial Reporting Council Ordinance, of course you can adopt a new drafting style or approach. But for the case laws accumulated under the common law, apparently applying the old approach of formula, it's richer under the common law system. So I don't know whether or not you have to pick this expression, or it can better reflect your policy intent. Otherwise, I would advise that you will adopt the older approach, that is, which would include all the interpretations in the case laws. Because if you adopt this expression, we do not have any authoritative case laws in respect of these new ordinances. So what is better, for example? So I would prefer that we adopt the old expression without effect if it doesn't affect your policy intent. I hope you will consider doing that. Would the Bureau reconsider this point? Thank you, Mr. To, and thank you, Chairman. Regarding this expression, the drafting of the law is evolving all the time. Mr. To pointed out that causes or allows have been adopted in some of the recently enacted ordinances. The most important point here is whether or not this expression can reflect our policy intent. It is indeed our policy intent that the relevant persons should deliberately allow this to happen before there would be an offense. So we believe that causes or allows has already correctly reflected a policy intent. We also respect the drafting style of the law draftsman. So therefore, we've decided to adopt this expression. Technically, may I ask another question? Or perhaps the law draftsman could comment here. When a company, breaches the law, I think the old expression is used. Now, in selecting this new expression, in this particular bill, in the context of this bill, is it better? Would it be the same or what? I mean, otherwise, I would rather that the law draftsman would consider, going back to the old approach, so that all the case laws relevant to companies breaching the law could also could apply.
It's a matter of policy rather than a drafting issue. It's already used in Section 13 of the Money Laundering Ordinance, the existing ordinance, and it is already in the Companies Ordinance. It is not, we are not talking of an offence in here. It's just a basis for disciplinary action, and also it's in relation to a director who allows the company or causes or allows the company to breach the law. Then that person becomes subject to disciplinary action. That is the context in which it is used in the current bill. But it's very common for it to be used in companies, in situations where company director allows something for the to happen for the company to breach the law. But you'll find that not only it's in the Securities Ordinance, Financial and Reporting Council Ordinance, Companies Ordinance, and the existing Anti-Money Laundering Ordinance, and various other ordinances. I believe Mr. To is, if I'm not mistaken, referring to offences, directors' liability offences in the common law. This is different. This is something like a regulatory regime. And you'll find that in all these ordinances, in the current Companies Ordinance, Securities and Futures, Inland Revenue Ordinance, and many other ordinances. Ultimately, it is really a matter of policy, but that this draft gives effect to the policy. But it is a very common approach, policy approach.
主席，我問一問，如果用翻
Madam Chairman, if we adopt the old expression, perhaps a legal advisor could help me here. Consents and connives, so connivance. I'd like to ask whether if we use that expression, we wouldn't be able to achieve the policy intent. If we use, consents and connives. So what's the difference between the two expressions? I
think causes, it's a higher threshold than connives. you actually cause that thing to happen and allows it to happen, it seems to be a higher threshold than consenting. Yeah.
OK，即係我可唔可以咁講啊？你揀呢
Can I put it this way? In picking courses or allows, you're deliberately, selecting, this which requires a higher threshold, right? If that's your answer, then I would have a different, consideration. Yes, here we're talking about courses or allows. Now, I think the mens rea here is that the person has the intention to allow something to happen. Compared with, connives and so on, the threshold is higher. Chairman, if the administration deliberately has chosen this higher threshold, then I wouldn't contest this any further. Okay, we'll put that on the record. Point, paragraph 10, Chairman. Paragraph 10 of paper 1 is also a response to a very good proposal by members. And we've now allowed to move a CSA so for when we need to appoint a third party overseas, the proposed new section will be refined to cover qualified estate agents in comparable jurisdictions as one of the specified intermediaries for carrying out the CDD measures. So this is simply to further clarify the point. Mr. Holden Chow, thank you. Whereas we discussed this at the FS panel yesterday, we're grateful for your heeding to our proposal. I'd just like to make a further point. If for the real estate agents, if they appoint third-party professionals to conduct know your customer or due diligence exercise, does the third-party professional, would they have to be in a third-party jurisdiction? Could they also be, local professionals? So there's no restriction here, right? I just want to clarify this point. So long as the due diligence is done. Thank you. If there are no further questions, Chairman, Mr. To, I have a question. Going back to Mr. Chow's point. Now, if we have a licensed agent, and during the first half of our discussion, we now understand how the regulation of real estate agents. But if you have somebody who never deal with local properties, you only sell overseas properties. Now, in our old laws, we don't have laws regulating agents who sell overseas properties. So in Hong Kong, how is it that we have this scenario? I mean, how can you do your due diligence in that case? Even if for the intermediaries, we do not just allow real estate agents, but anyway, for real estate agents, whether they are local or overseas intermediaries, including financial institutions, lawyers, trusts, and other license holders, they will all be covered. It's not just real estate agents, asking another real estate agent to help them conduct a due diligence. Well, as Mr. To said, if the agent only sells overseas properties, so in Hong Kong, he doesn't need to obtain a real estate license. But if he sells overseas properties, the real estate agents overseas will he have to be registered in that particular jurisdiction where the property is sold? Because the property is bought from overseas. The transaction takes place overseas. The person engaged in this transaction overseas, will they also need to be registered in the respective jurisdiction? And if they have to, will they be governed by the current bill or regulation? Well, we're now allowing the non-financial, practitioners, appointed intermediaries. Well, the onus still rests with the non-financial institutions. No matter how you make the appointment, eventually he will have to bear the responsibility. And secondly, the intermediary you appoint, it's not that anyone can become an intermediary. The intermediary must be regulated by the relevant jurisdiction and the anti-money laundering legislation before he is qualified. So if you appoint an overseas real estate agent, that agent, for example, in the UK will be governed by the anti-money laundering legislation there and so on. So in other words, before you make the entrustment or the appointment, you have to find out whether such a person is someone that you can trust and appoint as an intermediary. And remembering also that eventually you would have to bear the ultimate responsibility. So if he told you, that is, you have to find, in other words, an intermediary who is subject to regulation in the jurisdiction concerned. If the person, no, unless you have extraterritorial jurisdiction. For example, if I buy Japanese property, there's a person who is not licensed in Hong Kong. He will, help me with the transaction through a Japanese real estate. Is the agent in Japan licensed? Yes. No. Mr. Chow is not saying this. Mr. Chow is saying that I can appoint a local agent. They're saying that you can also do that. Okay, if you appoint an agent in Hong Kong, he will also need to have a license. But in this case, well, this is likely scenario, as I said, but it's not so in a majority of cases. I don't think Hong Kong intends to regulate the transaction on overseas properties. Yeah, it's very rare. No, it's becoming more and more popular these days. Most of the complaints we are now dealing with are people who are not licensed in Hong Kong, but they steal overseas properties. And they don't have a license overseas either. I think one of the councils under the DAB is also following up on similar cases. So who are the third party that I can rely to help me with the due diligence? Mr. Chow asked, what happens if somebody sells overseas properties? Well, he is not subject to regulation in Hong Kong. Can we appoint him as a third party? The present draft said so a person conducting similar experience in other jurisdictions. So although he is selling the properties in the other jurisdiction, but his business is located in Hong Kong. But using my other example, he's selling Japanese property, he doesn't have a license in Hong Kong. If he obtains a license in Japan, and you have a Japanese real estate agent coming to Hong Kong to set up a branch, well, in that case, they have to rely on Section 28(1)(c). So do we need to, ask the Hong Kong office or the Japanese office? Sorry, not coming through. So this person acting as a appointing the third party, he would need to find out whether the third party qualify as an intermediary, including, for example, locally, whether or not he is subject to the regulation, whether he is a financial professional or non-financial professional under the AML ordinance. And also for overseas jurisdiction, you need to find out whether there are similar ordinances regulating similar behavior. If all these conditions are met, then he can make the appointment so in that case, now, for example, if I'm a lawyer, I would need to handle an Italian transaction. If you have an Italian lawyer setting up an office in Hong Kong, I can trust him for the transaction. I understand Mr. Ho's point. A Hong Kong resident, deals with transactions in overseas property, such as Japanese properties, because I don't need to be licensed in Hong Kong. And I appoint a real estate agent in Japan, an agent in Japan, to help me with the transaction. And that Japanese agent is licensed, and he comes to Hong Kong to set up a branch. He would be conducting local businesses which have nothing to do with Hong Kong. He only needs to obtain a business registration. He doesn't need to become qualified as an EA. But so how do I conduct the transaction with this person? Well, the transaction takes place in Japan, right? So he appoints somebody who was licensed in Japan and who set up a business in Hong Kong to help him conduct the due diligence. For that due diligence, he will need to go back to Japan. He's setting up a branch in Hong Kong. He will need to obtain the information from his head office in Japan. No, it's not a question of obtaining the information. Now, if he set up an office in Hong Kong, does it satisfy the requirement in the bill? Is there parity here? I think the location of the jurisdiction is not the point. The point is whether or not the intermediary is qualified, and that includes whether he is covered by the AML ordinance locally, and if he's an overseas agent, whether or not he is bound by similar legislation. In other words, this intermediary or agent, so long as he is subject to similar AML regulation locally or overseas, then if due diligence is required, he is already qualified. Whether he sets up an office here or in Macau or Japan is immaterial. All right? Hold on. Chairman, having heard the administration, now the intermediary, whichever jurisdiction he practices his business, so long as he is bound by relevant anti-AML ordinance, it would be fine, right? That's what I heard. I think the enactment of the bill is pursuant to international requirements, and these requirements does not just apply to Hong Kong but globally. The relevant jurisdictions would all need to comply. I think that's the spirit, as the chairman has put it. The FATA said that all jurisdictions would require their financial professionals and non-financial professionals to conduct due diligence. When these people are subject to regulation, they can act as intermediaries to help the other party to conduct due diligence. So the question whether or not the intermediaries are, covered by the relevant AML ordinance in the jurisdiction concerned. All right? If there are no further questions, let's now move on to paper 444. That's the new marked up copy. Who would like to walk us through the amendment? Ms. Cheung. Thank you. This has already said that the for the three sets of CSA, I think we've already discussed this at the last meeting, including some of the provisions highlighted by the Law Society, and we have provided some clarifications here.
Allowing DNFBPs to commission intermediary, and the period, the duration of record keeping can be to at least 5 years instead of 6. So those CSAs may have some technical amendments, but it would be in essence, it would be what was discussed last time. And then this time we have some new CSAs. If we look at CB 1442 Bracket 02, Clause 7 is to add in Section 5A, to avoid doubt for the purposes of this section, it is immaterial whether the subject matter of a transaction referred to in subsection 3, 4, or 5 is in Hong Kong or elsewhere. So this is Clause 7 for the avoidance of doubt. Can we look at the marked up version, page 1? So we've added 5A, colored yellow here. 5A, colored yellow. Any question? Then can we go on? And then 8, clause 8. It was discussed last time. That is about the Law Society's sole discretion to determine the content of Practice Direction P. This can be seen on page 2, 5A, again in yellow. And then we go on to clause 9. It was also discussed last time. So there was a typo involving TCSP. All right. That's a rectification. And can clause 18 to allow rather 18 is about the disclosure by the registrar, that is to add EAA. That's on page 3 of the marked up version. It's colored yellow. That is to allow the registrar to make disclosure to the authority. And clause 26 to allow the NFBP to employ an intermediary. This can be found on pages 4 and 5. And we have discussed a lot whether the DNFPP is in Hong Kong as elsewhere, or to commission a relevant person elsewhere. 18.3a. So the red, you have scrapped the red fonts and you have added yellow. What about practicing lawyer and accountant in Hong Kong? An accounting professional, legal professional, have they included all? Yes. An accounting professional? No, it should be 人士. It should be 人士. All right, I think I am useful to a certain extent. Excellent, Mr. James Doe, you have done your homework well. All right, you have to correct this typo. The CSA, the 442 bracket 02 will contain all the CSAs. And then page 5, clause 26. the duration of record keeping changed from 6 years to at least 5 years. Record keeping requirements, that's on page 9. And then clause 34, discretion of the Law Society. Under what circumstances can the complaint be referred to as a disciplinary division? This on page 10 of the marked up copy. All right, please allow time for our members to consider these amendments first. Any question, Mr. James Stowe? Mr. Holden Chow, do you have a question? No? Then all right. So we have come. Do we? So we'll agree to the proposed CSAs by the administration. The legislative timetable is that resumption of second reading debate in the Council will be the 24th of January. And on the 12th, we are going to report to the House Committee, verbally, because that is cutting it very fine. I think I have to thank the Secretariat for doing its utmost in helping us. And the deadline for giving notice of amendment is the 9th of January. I might move a CSA on the counting of the offense. What is the deadline for giving CSA? It's the 15th. Following the timetable you outlined, Chairman, what is the deadline for giving notice of a CSA? The 15th. The deadline for giving notice of moving a CSA is the 15th of January. Mr. James Stowe may move a CSA. You may consider moving a CSA. On 53ZO, that is the limit of prosecution and when to start counting. All right, if there are no further questions, that ends the scrutiny of the bill. Any questions from the Secretariat? None. So the meeting ends here. Thank you very much.